under Trump 2025. So, as always, just a little bit of orientation about the webinar platform before I introduce our fabulous speakers for today. The webinar slides are available to the left side of your screen, along with a few helpful links if you would like to explore and learn more about compliance and risks and how we can simplify and accelerate your compliance processes. We want this webinar to be as engaging as possible, so please do send us any questions you may have and we'll aim to address them during the Q&A session at the end of the webinar. If you would like to submit a question for this Q&A session, please use the Ask a Question widget to the left side of your screen. We will follow up directly with you for any questions that we don't get to during today's webinar. And at any time, if you're interested in having a member of our team follow up with you, please don't hesitate to use the Start a Conversation button at the bottom of your screen. And last but not least, the webinar recording will be sent to you within 24 hours. So my name is Orla Morris and I'm the Content Marketing Manager here at Compliance and Risks. And I am delighted to be joined by this wonderful panel, starting with Corinne Laureson, Senior Regulatory Compliance Specialist with Compliance and Risks. She leads a team of 6 regulatory analysts and specialists based in both the EU and the US. She has qualifications in biology and in environmental and safety management. Prior to joining Compliance and Risks, Corinne worked as an environmental and safety consultant in the Netherlands and California. She has worked with compliance and risks for over 15 years and supports its clients with their global legal compliance challenges, with a particular interest and focus on the environment, occupational health and safety, and labour and employment. Thank you so much for joining us today, Corinne.
Thank you, Orla. Happy to be here.
Moving on to Patricia Weathers, a regulatory compliance specialist here with Compliance and Risks. Patricia joined Compliance and Risks as a regulatory compliance specialist in 2024. She is a certified lead auditor for ISO 13485 and ISO 9001 and has spent over 10 years working in quality compliance assurance in the medical device and automotive manufacturing sectors. Additionally, her background includes research and information services at the academic level and in training development. Thank you so much for joining us today, Patricia.
Hello, glad to be here.
Thirdly, Luisa Toro Correa, a regulatory compliance specialist with Compliance and Risks. She joined the Global Regulatory Compliance team in 2024, where she conducts regulatory monitoring on US states as well as internationally. Prior to joining Compliance and Risks, Luisa worked in overseeing the life cycles of projects and their outcomes, conducting one-on-one client consultations in R&D and product assessment, evaluating consumer product labeling for the North American market, supervising all regulatory compliance for the USA and Canadian consumer market, developing regulatory strategies and trained formulators and regulatory specialists in product labeling and safety. Thank you so much for joining us today, Luisa.
Thank you, Orla. Delighted to be here.
And last but certainly not least, we have Kyan So, a regulatory compliance analyst with Compliance and Risks. Kyan joined the company in 2024 and has academic backgrounds in neuroscience and criminology. Prior to joining Compliance and Risks, Kyan worked in the raw material regulatory field, focusing on chemical compliance with regulations such as RoHS, REACH, TCSA, and toxicology standards, including MSDS. She currently monitors the regulatory updates in South Korea, Greece, and US states, and serves as a secondary subject matter expert for medical devices. And thank you so much as well, Kyan, for joining us today.
Thank you, Orla. It is my pleasure to be part of this.
So before we kick off the webinar, I would like to just provide a background about compliance and risks for those who are joining this series for the first time. At Compliance and Risks, our mission is to help ensure global companies have the tools and information to build safe, sustainable products in a world full of change. We are the trusted product compliance technology provider for the world's leading brands and have spent 2 decades honing the digital tools, expertise, and content you need to stay ahead of the dynamic regulatory landscape and prove your product's compliance, protecting your brands and also helping to drive your growth. And at Compliance and Risks, we have the world's most comprehensive regulatory database with over 100,000 regulations historically available in C2P. With global regulatory coverage and expertise across over 10 industries, we understand that regulatory compliance definitely doesn't sleep. And our regulatory experts team is truly global, with 28 languages collectively spoken across the team, all fortified by our 30 knowledge partners. And C2P is our software, the key to unlocking market access as new products can be designed and built with full confidence you've met compliance obligations. It's designed to keep on top of regulatory changes and their impact worldwide, including early warning alerts, impact probability, productivity workflow tools, and so much more. And with that, I would like to hand it over to you, Corinne.
Thank you, Orla. And welcome, everyone. In this webinar, we will discuss environmental, social, and governance-related developments in the United States since the start of the second Trump administration. As we all know, a lot has happened since the inauguration of President Trump. We will discuss ESG developments on federal level, specifically presidential actions, related federal bills, EPA deregulation, and the SEC greenhouse gas emissions reporting rule. And we will look at ESG-related bills proposed in 2025 on state level. And we will finish with some key takeaways. And so we start with the presidential actions. Sorry, I went a bit too fast there. Oh, sorry. There we are. We'll mainly talk about the executive orders that President Trump signed. As you know, he has signed a lot of executive orders since January 20th, his inauguration day. So far, he has signed 143 executive orders. Compared to the previous administration, where there were only 162 executive orders signed, that's quite a lot. Now, something about executive orders. They direct a federal official or administrative agency to engage in a course of action or refrain from a course of action. The president who issued an executive order can revoke it, but also an incumbent president has the power to revoke an executive order issued by predecessors. Congress has the power to overturn an executive order by passing legislation that invalidates it. And finally, the courts have the power to stay enforcement or ultimately overturn an executive order that is found to be beyond the president's constitutional authority. What we've seen in relation to the executive orders and other areas, there are major policy shifts in ESG-related topics. One of the first executive orders that the president signed was rescissions of certain executive orders, like diversity, equity, and inclusion-related executive orders, climate change and related risks-related orders, and renewable energy transition executive orders. So he revoked several of those in the initial rescissions of harmful executive orders and actions, executive order, and the additional one that was signed later. Then in relation to climate change and change in energy-related policies, the president signed the executive order unleashing American energy. This one has a policy that really increases domestic exploration and use of oil, gas, and other minerals. It eliminates the electric vehicle mandate, and it requests freedom to choose from a variety of goods and appliances. Very recently, there was also a joint resolution in Congress signed that, for instance, asked to revoke energy efficiency standards for commercial refrigerators, freezers, and combined refrigerators, freezers. That's as an example of like the freedom to choose from a variety of goods of appliances. Then in relation to climate change, the president signed an executive order that asks for withdrawal from the Paris Agreement on climate change. And a notice was sent to the UN Secretary General on January 30th. The withdrawal will take officially effect on January 27 of next year. Related to this, or also as part of this executive order, the US International Climate Finance Plan was revoked and rescinded. And this plan was a framework outlining the United States' commitment to providing financial assistance to developing countries to help them mitigate and adapt to climate change. And another related dismissal is that all the authors of the 6th National Climate Assessment report were dismissed. And this report informs federal and local governments on how to prepare for climate change impacts. And as it was dismissed, this 6th report will not be written. Another executive order related to energy is the one called Protecting American Energy from State Overreach. This one directs the Attorney General to identify state laws relevant to climate change, ESG initiatives, environmental justice, carbon or greenhouse gas emissions, or carbon-related taxes and penalties. It orders appropriate action to stop state climate and energy-related laws and policies that may hinder domestic energy resource activities and may be unconstitutional, preempted by federal law, or otherwise unenforceable. And this executive order specifically targets state programs in California, New York, and Vermont. Then in relation to diversity, equity, and inclusion, this executive order ends as it is called, the illegal discrimination and restoring merit-based opportunity. It ends federal DEI and diversity, equity, inclusion, and accessibility workplace policies. It enforces compliance with existing federal anti-discrimination civil rights laws. DEI or DIA is no longer allowed in contracts with the federal government, and the private sector is also encouraged to end these kind of policies. The Attorney General is asked to report on DEI on publicly traded and large non-profit corporations. And related to this, the US Department of Labor stopped all equal employment investigative and enforcement activity. In a different area, the president issued an executive order pausing the Foreign Corrupt Practices Act enforcement. So the Foreign Corrupt Practices Act prohibits US citizens and companies from bribing foreign officials for business purposes. It mandates accurate record keeping and internal accounting controls for publicly traded companies. In the executive order, it says that the FCSP enforcement is overexpensive and unpredictable, and not only wastes limited prosecutorial resources, but actively harms American economic competitiveness and national security. The Attorney General is asked to do a review of guidelines and policy governing investigations and enforcement actions under the FCPA. And during this review period, the Attorney General shall cease to initiate new investigations or enforcement actions unless the Attorney General determines an exception should be made. She will review all existing investigations or enforcement actions and take appropriate action with respect to such matters to restore proper bounds on enforcement. And she shall issue updated guidelines or policies regarding conducting foreign affairs and prioritizing American interest, American economic competitiveness with respect to other nations and the efficient use of federal law enforcement resources. And the Attorney General has the option to extend the review period for another 180 days. In a different area, the President issued a very clear executive order on deregulation, also called the 10-to-1 rule, because this executive order says that for each new regulation issued by agencies, at least 10 existing regulations shall be identified for repeal. An earlier memorandum, regulatory freeze pending review, had already frozen issuance of rules and proposed rules pending approval by appropriate agency heads or officials. And then recently, on April 11, the Office of Management and Budget published a notice soliciting comments for deregulation. And it asks for any and all regulations currently in effect that anyone can say that should be revoked or repealed. Of course, there need to be good grounds for those repeals. The deadline for comments for this public consultation is May 12th of this year. So far, the executive orders. I will go now to some related federal bills. We saw the introduction in the Congress of House Bill 1553 and Senate Bill 720, companion bills, that proposed empowering and enforcing the Environmental Justice Act. This is in response to 200 employees placed on leave in the environmental justice programs at the EPA and the Department of Justice. It will establish an Office of Environmental Justice within the DOJ and promote environmental justice matters. Specifically, the responsibilities of this new office would be promoting and protecting the right of the public to participate in the decision-making process of environmental justice matters and facilitating a working relationship between parties involved in environmental justice matters, including regulated industry, government decision makers, nonprofits, low-income community, and indigenous populations or communities. As I said before, Congress has the power to repeal or revoke executive orders. And this one, House Bill 1781, proposes to repeal certain executive orders that President Trump issued. It's the executive order on unleashing American energy, putting America first in international agreements. That's the one that revoked the Paris Agreement, and declaring a national emergency, energy emergency. On the other hand, we also saw a Senate Bill 985 that is focused on prevention of regulatory overreach from turning essential companies into targets. It applies to US-based companies that do business with any part of the federal government, activities that are essential to the national interest of the United States, It prohibits companies from participating in foreign sustainability due diligence regulations, including the EU Corporate Sustainability Due Diligence Directive. Presidential exemptions are possible for hardship relief. And related to that, the US Chamber of Commerce published a letter on April 21st of this year, requesting the Trump administration to urge the EU to refocus application of the CSDDD exclusively on the European market. And now we go over to deregulation at the level of the Environmental Protection Agency. In March, the administrator of the US EPA announced 31 historic actions, 31 reconsiderations of EPA rules related to greenhouse gas, renewable energy, DEI, etc. Anyway, I'm not going to talk about all these 31 historic actions. I just want to point out a few. So they are reconsidering the greenhouse gas reporting program that required larger industries to report on greenhouse gas emissions, reconsideration of the risk management program rule, the rule for oil and natural gas refineries and chemical facilities to improve safety. Another one is the automotive greenhouse gas rules, greenhouse gas emission regulations for light duty, medium duty, and heavy duty vehicles. The 2009 endangerment finding, this is the scientific basis for regulating greenhouse gases under the Clean Air Act. And another one is the technology transition rule that limits the use of climate damaging HFCs in sectors like food and semiconductor manufacturing. So all these regulations and many others are going to be reconsidered by the EPA. And we will see what's going to happen with them. I will now pass over to my colleague, Patricia, who will give us more insight in what's happening with the SEC greenhouse gas emission reporting rule.
Thank you, Corinne. All right, closing out our federal level review, we'll take a look at the greenhouse gas emission reporting rule from the SEC. Basically, that measure, that rule had taken 4 years for the SEC to develop and put in place. It released it in March of 2024. However, 1 month later, it was suspended pending judicial review. So as we look at this rule in 2025, we see that initially in February, there was disagreement among the commissioners at the SEC. But what it came down to in March was that the then chair, Ueda, stopped its defense of the rule. And at the end of April, we saw a new chairperson announced, and he has made no changes in that action. So as of this date, businesses don't have to follow or report anything with regard to their greenhouse emissions per this rule, as it is in effect, or as it's not in effect, I will say. Now we're going to change direction, and we're going to get to a much more micro level and look at US state level legislation that's occurred in 2025. With regard to ESG reporting and supply chain disclosures, we're first going to take a look at 4 bills that cover ESG reporting and supply chain disclosures, due diligence, and the like. The federal laws seem to be languishing at this point, but a few states are acting with regard to ESG reporting, supply chain disclosures, as well as corporate due diligence. Taking a look specifically at the fashion industry and fashion producers. We have at least 4 bills proposed, and each includes industry supply chains in the due diligence process. As you'll see, we'll start with the New York Senate Bill 4558B. This is actually a reintroduction of the 2023 bill, and it would require fashion sellers and their supply chains to minimize greenhouse gas emissions and implement wastewater testing for significant tier 2 suppliers. So not just the direct, but also tier 2. Also, they should foster compliance with OECD guidelines and setting greenhouse gas emission reduction targets. The second one you see on the screen is from Massachusetts, House Bill 1032, and it would require supply chain mapping as well as submission of environmental due diligence reports within 18 months of the bill's taking effect. Also, any non-compliance could result in a fine equal to 22% of annual revenue. Moving on to the next bill under this category, the 2025 California Fashion Environmental Accountability Act follows on the heels of the state's 2024 Responsible Textile Recovery Act. 405 is meant to reduce harmful chemicals and producers' carbon footprints, as well as align the state with international Paris Agreement, unlike at the federal level. A 2021 landfill report states that textiles are 3% of California's waste. So reporting and disclosure of GHG emissions would begin in 2027 if this bill passes. Rounding out this section, we have Washington's House Bill 1107. This bill would require fashion producers and fashion sellers to report environmental impacts beginning in 2027. Fashion producers with an annual worldwide gross income exceeding $100 million would also have to report their working conditions and those of their direct suppliers. Next, let's take a look at some of the state legislation with regard to human rights affected communities. For this, I'll talk about the 3 proposed state bills you see on the screen. First, we've got New York State Senate Bill 1493. This bill proposes that businesses near or within disadvantaged or impacted communities will likely encounter more attention from the Department of Environmental Conservation for New York, and they'll face potential liability for PFAS emissions that they produce. The bill would require them to implement control technologies such as activated carbon filtration, soil stabilization, or ion exchange to mitigate or eliminate the PFAS contamination in water, soil, or air. Second is Illinois Senate Bill 1307. This would be an amendment to the state's Environmental Protection Act. It would require businesses that plan to build a facility in an identified Illinois environmental justice community to have a third party conduct an environmental justice assessment. They would then have to hold a public meeting to present the results of that, and then allow 30 days for public comment and response. Lastly, we see California has Assembly Bill 362. This aims to add tribal water as part of the protected state waters. It would require any project subject to State Water Quality Control Board approval to identify quantitative and qualitative data and how the project will impact tribal water uses. Now I will hand off to my colleague Luisa for state legislation and climate change.
Thank you, Patty. We're going to discuss ESG developments focusing on state-level legislative efforts related to climate change disclosures, accountability, and mitigation. New Jersey, New York, and Oregon are proposing to advance climate accountability legislation in the face of potential federal rollbacks. New Jersey's Climate Corporate Data Accountability Act focuses on public disclosures on greenhouse gas emissions by large businesses, with escalating reporting requirements and administrative oversight by the DEP. In comparison, New York's Climate Corporate Accountability Bill also mandates emission disclosure for major companies, emphasizing compliance with the Greenhouse Gas Protocol and third-party data assurance, while Oregon Climate Accountability and Damages Act takes a different approach, establishing liability for significant greenhouse gas emitters for damages caused by climate change. These state-level efforts demonstrate a strong trend towards increasing corporate responsibilities for climate impact. Also, these initiatives demonstrate a growing trend towards corporate climate accountability. New Jersey and New York focusing on emissions transparency through mandatory reporting. Oregon's bill proposes a unique approach by establishing liability for climate-related damages. These legislative efforts could significantly impact large corporations operating in these states and potentially serve as models for other jurisdictions. Lastly, all these three bills are proposing penalties for noncompliance. Here we see New York again, along with Illinois, growing a focus on corporate emissions, transparency, and accountability. With these two proposals, we see the increasing recognition of significant roles corporations play in greenhouse gas emissions. So we ask ourselves, what are these states-level initiatives? Well, target large corporations, reporting on scope 1, 2, and 3, adherence to greenhouse gas protocol standards, third-party verification on reported emissions, and also the aim for public disclosure of emissions data. I would also like to briefly touch on the implications for businesses, which are reporting obligations, a robust system to track and calculate scopes 1, 2, and 3, as well as an increase of transparency regarding environmental impact. Businesses need to proactively prepare for these requirements to ensure compliance and effectively manage their environmental responsibilities. The bills also propose penalties for non-compliance. In a continuation of discussing corporate transparency, I want to discuss this New York bill regarding the financial risk associated with climate change for large businesses operating in the state. Corporations must prepare and disclose reports detailing the financial risk they face due to climate change. These reports must also include the mitigation measures entities are taking to address these risks. Corporate reports are aligned with the Task Force of Climate Change-related financial disclosure recommendations or an equivalent standard. Failure to comply can result in penalties. State regulations, particularly in influential markets such as California, are the primary drivers of USA emissions transparency, setting a stringent standard that encourages other states to adopt similar measures. Now we're going to discuss mitigation efforts regarding carbon dioxide removal, hydrofluorocarbons, and blends with a high global warming potential. Both California and Washington are actively pursuing legislative measures to address these greenhouse gas emissions. California is focusing on ensuring the integrity and effectiveness of carbon dioxide removal strategies, while Washington is targeting the potent greenhouse gas found in hydrofluorocarbons through direct prohibitions and improve and adhere to refrigerant management practices. I want to come back to California and discuss this bill a little bit more and explain that entities aiming to meet net zero targets or offset emissions under the Climate Corporate Data Accountability Act are obligated to use qualified carbon dioxide removable methods that meet specific requirements. But yet this has to be defined. This means that once the state board adopts protocols for the utilization and storage of capture and remove carbon dioxide, relevant entities will be obligated to adhere to these protocols. And touching a little bit on the Washington bill is creating a direct prohibition on the sale and distribution of high global warming potential hydrofluorocarbons, thereby obligating relevant actors to transition to an alternative and improve refrigerant handling. These thresholds are proposed to become more stringent every 3 years. In a continuation of mitigation, we see that New Jersey is strengthening its greenhouse gas monitoring and reporting by amending its 2007 Global Warming Response Act. New Jersey has now included nitrogen oxides and hydrogen in their greenhouse gas definition. The state proposes amendments focusing on improving the accuracy, scope, and timeframe of greenhouse gas emissions monitoring and reporting. In contrast, New York seeks to create a market-based mechanism to drive down the greenhouse gas emissions across the state's economy, specifically focusing on environmental justice for disadvantaged communities. New York proposes to establish this cap and invest program by setting an economy-wide cap on total allowable emissions, decreasing annually, selling emissions allowances to cover sources, and penalizing emissions exceeding submitted allowances. So we see both New Jersey and New York actively pursuing legislative measures to enhance their mitigation efforts. Now, some proposals on greenhouse gas emissions. Here we examine recent legislative developments in 3 U.S. states: Oregon, Vermont, and Rhode Island. These actions highlight diverse approaches to climate change policy, ranging from strengthening reduction targets to proposing the repeal of existing mandates. Oregon is proposing to significantly strengthen its greenhouse gas emissions reduction targets, and it even targets net zero emissions by 2050. Vermont is aiming for a very ambitious net zero emissions goals by 2035. So this means that Vermont will be changing its requirements for emission reductions. And Rhode Island is considering a complete repeal of its existing climate mandate, which it doesn't come to a surprise with the current administration. These states' developments illustrate the dynamic and varied landscape of climate policy at a state level in the U.S. To wrap up climate change, I want to briefly discuss the latest draft regulations proposed by the New York State Department of Environmental Conservation. This proposal established a comprehensive framework for collecting emissions data for a wide range of sources. Some of the obligations are monitoring, calculating, among others. The state aims to improve its ability to reduce pollution, strengthen community resilience, and facilitate the transition to clean energy economy. It's crucial for potential affected entities to carefully review the draft regulations, understand their obligations, and actively participate in the public comment process. This brings us to an end of climate change. But before we move on, I want to reiterate the diverse array of assertive policy responses climate change at a state level. Next is Kayan, and she will be navigating you through ESG developments in labor and employment at a state level. Thank you.
Oh, thank you, Louisa. So labor and employment is an area we're seeing a lot of legislative activity this year. In fact, we've tracked over 500 labor and employment bills proposed across U.S. states in the 2025 legislative session alone. To make this vast information more manageable, we've organized these bills into 6 key categories. This categorization is based on prominent policy trends and recurring themes that clearly reflect the current priorities in workplace regulations. Let me walk you through these themes in the next few slides, starting with protections for pregnant workers. So we're seeing several states introduce legislation to prevent discrimination based on pregnancy, childbirth, or related medical conditions. Let's take Arizona's Senate Bill 1401 as an example, as it's pretty representative of what many states are considering. This bill emphasizes reasonable accommodations, which is about making adjustments to the workplace to allow a pregnant employee to continue performing their job safely and effectively. This could include things like providing more frequent breaks, offering different seating, or adjusting work schedules. Also, it addresses leave usage. The bill clearly states that if a reasonable accommodation is possible, an employee should not be forced to use their annual leave, vacation time, or sick leave, so that pregnant workers can keep their leave available if they need it for other reasons or later in the pregnancy. There is also a focus on reasonable accommodation notice. Employers have an obligation to inform their employees about these protections. This means they need to post notices conspicuously in the workplace, include this information in their employee handbook, and provide this information to new hires when they start, current employees within 180 days of the law taking effect, and of course to any employee who is pregnant. Essentially, states like Arizona and others like Tennessee, Texas, Connecticut, and New York are aiming to create a more supportive environment for pregnant individuals in the workplace, ensuring they receive the necessary accommodations to maintain their employment. Continuing our look at essential employee protections, let's now talk about paid sick leave. We've seen a lot of activity in this area, with Michigan leading the charge by enacting its House Bill 4002, the Earned Sick Time Act, which became effective in February of this year. This act is important because it guarantees Michigan workers the right to earn sick time for a variety of reasons. This isn't just about traditional sick days, it's also about acknowledging the broader needs of employees. This act ensures that paid sick time can be used for things like personal or family health needs, situations involving domestic violence or sexual assault, school meetings related to their children, and even things like menstrual and menopause health. There is also a growing trend across states like Kentucky, Oregon, Tennessee, New York, and New Jersey, where similar legislation is being proposed. There's clearly a strong push to provide these essential protections and ensure fair compensation. Now let's break down the specifics of Michigan's Earned Sick Time Act. Here are the key points. Accrual and hourly caps. Employees earn at least 1 hour of paid sick time for every 30 hours worked. Small businesses have a cap of 40 hours per year, while other employers have a cap of 72 hours unless they choose to offer more. Any unused sick time can be carried over from year to year, again up to those same 40-hour or 72-hour limits, unless the employer provides the full amount of sick time upfront at the start of the year. And as I mentioned earlier, this earned sick time can be used for a variety of reasons. And lastly, the Act includes strong protection against retaliations. Employers cannot take action against an employee for requesting, using, or enforcing their rights under this law. Following our discussion on paid sick leave and ensuring employees have time off for their health needs, let's focus on states' attention to the standards surrounding work hours themselves, specifically breaks and overtime pay. Across states like Arizona, Georgia, Nebraska, Maryland, and New Hampshire, there's a clear focus on creating a better work-life balance by both mandating breaks and regulating overtime pay. First, they focus on establishing new labor standards, which includes defining clear guidelines about how and when breaks should be provided, ensuring clarity for both employers and employees. And many states are working to regulate meal breaks by setting requirements for the duration and timing. There is also a push for mandatory rest breaks throughout the day, and overtime pay compensation ensures that employees are accurately and fairly compensated for any hours worked beyond the standard work week. Lastly, with the growing prevalence of remote work, there's a need for addressing remote work pay and break requirements. Now, let's shift gears a bit and talk about something really current, the increasing use of artificial intelligence in the workplace. Here are the key themes that states like Illinois and New York are focusing on. First, there's a big emphasis on bias audits to make sure that any AI system used in hiring or management decisions is fair. These audits check for discriminatory biases related to things like race, gender, disability, and religion. Next is transparency. Employers increasingly being required to be upfront about how they're using AI. This means informing employees and job candidates about automated decision-making tools and how they work. On top of that, they might need to submit AI impact assessments. It is crucial to have anti-discrimination measures in place to ensure that AI-driven decisions do not lead to unfair treatment in hiring or management, which we will discuss in more detail on the next slide. And finally, there are worker rights related to AI. This includes protection against constant AI surveillance, and also workers should have the option for human review of decisions made by AI tools and need to be informed about any monitoring practices in place. Moving on to the topic of discrimination, there were a number of bills aimed at prohibiting various forms of discrimination, and we can broadly categorize them into these three key areas. First, there are measures protecting employees from appearance or age-based discrimination, aiming to stop workplace bias based on physical appearance or age, ensuring individuals aren't unfairly disadvantaged based on these characteristics. Second, there's an increasing focus on regulating AI-driven discrimination in hiring and management. These bills address and prevent discriminatory outcomes arising from the use of AI in recruitment and workplace decision-making. And finally, there's a movement towards prohibiting non-disclosure and non-disparagement agreements related to discrimination or harassment. Essentially, these provisions prevent employers from silencing employees who experience discrimination or harassment. States like Illinois, Texas, Hawaii, Massachusetts, and Oregon are among those considering these type of protections. Now let's discuss wage transparency. There is a strong push for fairer compensation practices through several proposed bills, each focusing on key measures. First, there is salary range disclosure requirement in job postings. Many states are considering or have already mandated that employers include salary ranges or fixed pay rates in their job advertisements. Next is the prohibition on salary history inquiries. The idea here is to prevent employers from asking job candidates about their previous salaries. Then we have pay range disclosure to current employees. Some bills would require employers to share pay ranges for current positions when an employee requested or when they're being considered for a promotion or other new opportunity. Finally, efforts to enforce stronger pay equity laws. This includes increasing penalties for employers who violate equal pay laws and improving the mechanisms for enforcing those laws. It's worth noting that we're seeing these type of bills being proposed in states like Arizona, Oregon, Virginia, New York, and Rhode Island, among others. And you can find all the details on these specific bills within our C2P platform. Now I'm gonna pass it back to Corinne for our key takeaways.
Thank you, Kayan. Yes, to wrap up the webinar of today, what we've seen is that ESG has become a highly politicized issue in the US, with significant divisions between those advocating for greater corporate transparency and those concerned about regulatory overreach. Federal ESG initiatives are actively being rolled back, but states are pushing ahead with their own ESG regulations. Lack of federal guidance is creating a patchwork of regulations between the states, and regulatory tracking and horizon scanning tools like C2P are important to stay on top of all these developments. But despite the backlash, new reporting by Reuters recently provides strong evidence that US companies are maintaining, even planning, to expand their sustainability commitments. And let's be clear, material risks haven't disappeared. Investors are still asking pointed questions about transition exposure and long-term viability. Consumers remain attentive, particularly in sectors like food, fashion, and mobility. And climate events, from floods to wildfires, are only accelerating. The pressures are still here, and it's up to you to respond to them. And I will now pass back to Orla again.
Brilliant. Thank you all so much. That was a wealth of information. And thank you all as well so much for your attention. We have now opened the floor for the Q&A session. And as I said at the start, if you have a question that you would like us to answer, please let us know using the Ask a Question widget. And we've had a lot of questions coming in during the course of the webinar, so thank you all for your engagement, and we'll answer some of them now. So Corinne, to what type of companies does the Protect USA Act apply?
I will take that one. This act is the Senate Bill 985 that I spoke about. It applies to companies that are considered important to the national interests of the United States, and this includes companies that do businesses with the federal government, that are organized under U.S. laws, and have significant portion of their revenue from industries like extraction of raw materials, manufacturing, and defense. And specifically, it aims to protect these companies from being forced to comply with foreign sustainability due diligence regulations like the EU CSDDD regulation.
Brilliant, thank you.
Yeah.
And another question, what information has to be included in the AI impact assessments?
I can take that question. So the details you need for these AI assessments change a little depending on the state, like in Illinois and New York, for example. But generally speaking, you're looking at doing risk-based evaluations roughly once a year or more. And things like what the AI tool is for, how it handles data, if it could have a negative impact on anyone, and what you're doing to prevent that should be included in the assessments. Additionally, if you make any big changes to the AI system, you will need to submit an updated assessment on that too.
Thank you, Kyan. What key obligations would the New York State Department of Environmental Conservation's draft regulations impose?
Thank you, Orleth. I can take that one. Facility owners and operators must annually submit emissions data reports covering all applicable source categories and greenhouse gas emissions using specified methods, and monitor and submit these reports to the department. Additionally, the reports are subject to verification and are required to be verified by third-party accredited bodies, with verification statements due annually as well. Facility operators must also report changes in operations or status resulting in 5% increase or decreased emissions. The verifiers must ensure accurate reporting and avoid falsifying or concealing material facts. Thank you.
Thank you, Louisa. And I think we'll take one more. What is meant by an environmental justice community in the Illinois bill?
Thanks, Ola. I can take that one since I introduced that bill. Illinois, such as most states, they define an environmental justice community as a neighborhood or an area that suffers disproportionately from environmental impacts or hazards. Often these are identified as marginalized communities, especially communities that are typically located near or adjacent to or within a certain mile radius of industry, that kind of thing. And so it's particularly concerned with the environmental impacts to human life and health, especially if there have been any, I guess, records of an increased suffering from any type of health conditions by the people living in those communities. Thanks.
Thank you all. So I think we'll, any questions that weren't answered during this Q&A session, again, will be covered after this webinar, and we'll reach out to you directly with an answer. But I just want to thank you all so much for tuning in with us today. We all hope you found today's presentation helpful, and we look forward to seeing you in our upcoming webinars. You can check out our resources section on our website to stay updated and to access our latest white papers, blogs, and webinars, both on demand and upcoming webinars will be featured there. And on that topic, we do have plenty of upcoming content as we continue into 2025. So please do make sure you keep an eye out. Our next webinar, EU and UK product compliance, what's hot in 2025 and beyond, is taking place on May 21st, led by our knowledge partner, Cooley. So we hope to see you there. Thank you all again for joining us today, and have a wonderful rest of your day.